In today's video, I will give you an insight about the statement of the accused recorded under section 313 CRPC. 313 CRPC postulates and empower the court to examine the accused and gives an opportunity to the accused to give an explanation of the incriminating circumstances which are adduced by the prosecution during the course of the trial. The statement of the accused, which is recorded under section 313, serve dual purposes. The first purpose, it gives an opportunity to the accused to give an explanation of all those circumstances which are adduced and produced by the prosecution during the trial. And second, if the accused gives the wrong explanation of any fact which had been proved by the prosecution during the trial, then an adverse inference can be generated against him. There are certain principles that governs the recording of the statement of section 313, and the first and the foremost principle is that the formulation of the question by the court must be simple, unambiguous, and free from all sort of legal jargons. It should be understandable to the accused so that the accused can furnish the explanation of the circumstantial evidence or the circumstances material. It should not be of the nature which have a confusing tendencies. But it is not necessary that the accused must answer all the questions. He can exercise the right of silence also. He can also even give the false answer. For that end, the adverse inference can be generated against him, but he cannot be prosecuted for giving the false answer or for the perjury. And the reason is simple, because while recording the statement of the accused, no oath is administered to him. Now the prime question arises whether the conviction can be held on the basis of the admission by the accused about his guilt. And this is the prime question. And the answer to this question is very simple. The statement of the accused is not been recorded without administering him the oath, and the statement is not an evidence within the meaning of section 3 of the Indian Evidence Act. And it is this fundamental principle that whenever the conviction is held, it should be held on the basis of the substantive piece of evidence, and the statement so recorded of the accused shall not be subject of the cross-examination also. So in this situation, when the statement is without an oath, when the statement has not been subjected to cross-examination, in this situation we can easily say that it is not a substantive piece of evidence, and therefore conviction cannot be held simply on the ground that the accused has admitted his guilt in his statement recorded under section 313. But at the same time, if the accused admits his guilt, that part of the statement of the accused cannot be washed off or ignored at all, but it is considered if the case is based upon the circumstantial evidence and the accused gives the false explanation of the established facts, then that false reply is considered as a missing link for the purpose of completing the chain of circumstance against him. And this is very essential that while arguing the case by the prosecution can pick up those missing links from the statement of the accused during his recording under section 313. Now, sometimes it also happens that the courts formulated the questions, and while formulating the questions, assembled and string up so many incriminating circumstances together and put to the accused in the form of a single question. The Honorable Supreme Court and many high courts has clear on this point and specifically held that the statement recorded under section 313 is not merely a paper formality, and it is a serious business, and this kind of the practice must be deprecated. It is impermissible under the law. Each and every circumstance must be separately put to the accused, and for each and every circumstance the specific answer must come out from the side of the accused. And if many questions are assembled together, then that will simply confuse the accused, and the accused would not be in a situation to answer it correctly, and often get confused that which part of the question he must accept and which part of the question he must reject. Now, another aspect which I think are requires the clarification is the answer given by the accused in his statement under section 313 must not be seen in isolation but in conjunction with the rest of the evidences. And again, it is not always mandatory that this statement must be recorded. It can be dispensed with. But in those situations where there is no incriminating circumstance against the accused, suppose during the course of trial, no incriminating circumstance emerged on the record, then there is no legal obligation on the court to record the statement of the accused under section 313, because if there is no incriminating circumstance, there is no reason to record the statement. These are some of the dimensions and aspects of the statement of the accused under section 313, and I think that it would provide you a little bit of insight about the provisions and its various dimensions. Thank you.